Good morning. I hereby call to order this fourth meeting of the Pennsylvania Public Utility Commission for the year 2025. We welcome everyone joining us here in the room, as well as those watching on the live stream. Please stand for the Pledge of Allegiance. At today's meeting, which is open to the public, the Commission will act on various matters. Since adequate forms have been made available for public participation in cases before the Commission, there is no opportunity for the public to address the Commission at this public meeting. Public meeting motions, statements, and video will be available on the Commission's website later today. The first matter on this morning's agenda is the approval of the minutes of the meeting of January 23rd, 2025. I would like to recognize Commissioner Yanora as the editor of the minutes. Commissioner Yanora.
I reviewed the minutes of the January 23rd, 2025 public meeting and move that they be approved as submitted. Thank you.
You've heard the motion by Commissioner Yanora. Is there a second?
Second.
Seconded by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye. Aye. Those opposed, no. The ayes have it, and the minutes are approved by a vote of 5-0. Madam Secretary, we're ready for your presentation.
Good morning, Mr. Chairman and Commissioners. Your various bureaus and offices have prepared the following agenda for your consideration. Therefore, let us begin on page 1 with matters presented by Director Hafner and the Office of Special Assistants. It should be noted that the single item on page 1, the formal complaint of Gregory and Donna Colmar versus the West Penn Power Company, has been postponed until the public meeting of March 13, 2025. Turning to page 2, it is recommended that the Commission adopt the proposed opinion and order in the informal investigation and settlement agreement between the Bureau of Investigation and Enforcement versus Columbia Gas of Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second? Motion made by Vice Chair Barrow, seconded by Commissioner Yanora. Any discussion?
Mr. Chairman, I have a statement.
Commissioner Zerfus.
Thank you, Mr. Chairman. Madam Secretary, please add my statement to the record as if I read it in its entirety. Before us today is a proposed joint petition for approval, a settlement filed by the Commission's Bureau of Investigation and Enforcement and Columbia Gas with respect to an informal investigation conducted by I&E. During an investigation, I&E engineers found evidence of a weld burn through on one of the welds on a pipe at a Columbia Gas regulator station located in Rochester, Beaver County. A weld burn through occurs when excessive heat during the welding process creates an open hole. While various techniques or protocols can be used to repair these kinds of holes, it's important to test gas pipelines for leaks after such repairs to ensure the pipe's structural integrity has not been compromised. A contractor employed by Columbia had created the burn through and then seemingly attempted to repair it, all while the pipeline was in service. The regulator station and the pipe in question remained in service for approximately 4 months before this issue was discovered, at which point the regulator station and associated pipe were taken out of service so that the proper repairs could be completed. Columbia's welding manual outlines procedures for performing in-service welds. However, at the time of this incident, the manual did not specify whether repairing a burn-through could be or should be done while the pipeline was in service. As part of this settlement, the parties have agreed to Columbia Gas paying a $9,000 civil penalty and implementing remedial actions, including but not limited to reviewing and revising its current QA/QC practice for welds completed by third parties, conducting a casual analysis whenever a pipeline burn-through occurs on an in-service pipeline, and updating its welding manual and related training materials to refine in-service welding procedures. Thankfully, no one was injured and no property was damaged in this incident, though such outcomes are entirely possible. In the recent past, several significant natural gas explosions have taken place, resulting in tragic loss of life, severe injuries, property damage, and likely financial or economic setbacks for affected communities. These recent serious incidents serve as a vital reminder of the need for strict safety precautions when working with natural gas pipelines. The safety of Pennsylvanians is paramount. The Commission is charged with investigating incidents and possible violations and ensuring that penalties are strong enough to hold responsible parties accountable. I do not believe that the $9,000 penalty in this matter meets the severity of the incident and is woefully inadequate given the circumstances. In spite of my concerns about the dollar amount of the penalty, I will be voting to approve the settlement because it is important to memorialize the remedial actions contained therein. Thank you, Mr. Chairman.
Thank you, Commissioner Zerfus. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. Matter passed by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 2, it is recommended that the commission adopt in an omnibus motion the formal complaint of Ronald and Sheila Darien versus the Pennsylvania American Water Company, and continue, include, and end the omnibus at the top of page 3 with the formal complaint of Marissa Diaz-Willis versus the Philadelphia Gas Works.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matters passed by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 3, it is recommended that the commission adopt the proposed opinion and order in the petition filed by Michael L. Sparazza et al. Versus PPL Electric Utilities.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Yanora. Any discussion?
Chairman, I have a motion on the matter.
Commissioner Yanora.
I ask that my motion be entered into the record as if I read it in its entirety. Before the commission is PP&L's petition for a waiver of the disc cap. I believe that PP&L has established that a waiver is necessary to ensure and maintain safe, reliable, and adequate services. Over the past several years, PP&L has had issues with meeting commission electric reliability benchmarks. Additionally, PP&L states that maintaining service reliability is becoming more difficult due to the severity and frequent of weather events, aging infrastructure, and rising supply costs. The Commission values the need for infrastructure replacement. Granting a disc waiver will work to accelerate PP&L's infrastructure improvements. It will also assist with customer affordability by reducing the frequency and the cost of rate cases. Further, the Commission's disc review process offers robust consumer protection through the comprehensive scrutiny of PP&L's long-term infrastructure plans. As such, PP&L's disc cap should be set at 7.5% until the effective date of rates established in the company's next base rate case or at the end of the company's current LTIP, whichever occurs first. I find that this temporary waiver is reasonable and is to the public's interest. Therefore, I move that 1, the exceptions of PP&L's Electric Utilities Corporation to recommended decision of Administrative Law Judge Ashton are granted in part and denied in part consistent with this motion. 2, that the recommended decision of Administrative Law Judge Ashton is modified consistent with this motion. 3, that the petition filed by PP&L Utilities Corporation seeking a waiver of its disc cap and approval of the increase of the disc cap is granted in part consistent with this motion. 4, that the formal complaints filed regarding this matter are dismissed and marked closed at the Commission's Secretary's Bureau. And 4, that the Office of Special Assistants prepare an opinion and order consistent with this motion. Thank you.
You've heard the motion by Commissioner Yanora. Is there a second?
Second.
Seconded by Commissioner Coleman. Any discussion? We're on the matter. I'm going to speak now on the motion.
You go on the motion.
Okay.
Yeah, Mr. Chairman, I have some verbal
Mr. Zerfus.
comments. Thank you. So we heard that PPL is asking for a waiver to its disc cap, which means that they're asking for an ability to raise revenue outside of a rate case, which is certainly allowable by law, and the disc has been a good tool in the toolbox since it's been implemented. This motion would approve the waiver to go above the 5% cap, as we heard from Commissioner Yanora when he read his motion, and it would go to a 7.5 cap, which is lower than requested by PPL. They originally asked to go to 9%. Going to 7.5% cap equals $28 million for PPL, and that money would be paid by PPL's customers. If we are asking our ratepayers to pay more, particularly through a process that is more streamlined than a rate case, I want to be extremely careful in the review of the request to make sure that we are asking our ratepayers to pay more for good cause. In reading the materials provided by PPL and in review of the staff recommendation, which was to ultimately deny the request to go above the 5% cap, I do not find any compelling argument or reason why we should grant the waiver. PPL says in their own documents that there is no risk of non-compliance with their LTIP, meaning that even without this waiver, they will still be able to meet the need for appropriate infrastructure investments. I do not see anything in the request that says that customer safety is at risk or that they will fail to meet reliability benchmarks. I do see in the request some comments about needing to recover from a series of storms that occurred a couple of years ago, but they said it was mostly related to vegetation management. I do see a comment that they will likely come back to the Commission in 2026 with a rate increase request. So given the lack of any kind of public safety emergency or emergent infrastructure need or some other kind of emergent need, I agree with the staff recommendation to deny the request. I see no reason why I would vote to allow them to recover additional money from their customers, particularly seniors and families, at a time when people back home are struggling to pay for essential needs and goods, everything from eggs to diapers to utility bills, and especially when the company says that they will be asking more of their customers next year. So I will be a no on this motion. Thank you.
Thank you, Commissioner Zerfus. Any further comments? On the motion, all those in favor, please say aye.
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 No.
Those opposed, no.
No.
The ayes have it. The motion passes by a vote of 3-2, noting the dissents of Vice Chair Barrow and Commissioner Zerfus. On the matter as amended by the motion, are there any comments?
Chairman, I do have a statement.
Vice Chair Barrow.
Madam Secretary, please enter my statement in the record as though read in its entirety. The basics of a DISC is that it's a surcharge placed on customers' bills to accelerate the replacement of existing aging facilities. Since 2014, PPL has spent over $500 million in DISC-related infrastructure improvements. Based on PPL's 2024 DISC report, PPL's revenues at the current 5% DISC cap, approximately $57 million. At a 7.5% DISC cap, that would be $86 million, and at the requested 9%, it's approximately $102 million. When we approve a DISC, the Commission is giving approval for the utility to receive a return on its dollars spent on replacing facilities or plant and service without the utility having to go through a lengthy base rate proceeding. And this makes the DISC a win for the utilities financially, and it's a win for the customers, because accelerating replacement of faulty facilities, faulty plant, translates into, depending on the type of utility, less main breaks, less line losses, less line failures, less equipment failure, and increased safety. All in all, more reliable service. In this petition, PPL argues that it needs to collect more money through the DISC so it can maintain and improve reliability of services because, as mentioned by Commissioner Zerfus, they're seeing more frequent and severe weather events. They're seeing increased material costs, and that is putting some pressure on their budgets. I do not doubt PPL's statements regarding the increased facility costs, but I do take issue with using this particular mechanism to meet those costs when a utility has not been in for a base rate filing in a decade. They last filed in March of 2015, and those rates were effective in January of 2016. And they've stated they will not be in until 2026. I agree with the ALJ's determination that in this case, a base rate filing would be the more appropriate way of seeking additional revenues to fund system enhancement. And that's because with a base rate filing, by no means am I saying that the companies need to file every year, every 2 years. But every now and then, please, because there's consumer protection built into litigating a rate case. The advocates get to take a look at the finances. The commission gets to take a look at the books. And that kind of scrutiny is not afforded with a DISC filing. So undoubtedly, the DISC has been a useful mechanism in Pennsylvania, and every utility should continue to avail itself to using a DISC. I agree that properly implemented, the DISC keeps the utilities out from those rate cases, and it provides the dollars they need for infrastructure. But two things can be true, and two things are true here. The DISC mechanism absolutely works, but it is quite possible to overuse a good thing. The statute, in recognition that a DISC is a pass-through rate collected outside of a base rate filing, does include consumer protections. And there's a requirement that a utility, the first time it's seeking to implement a DISC, must have filed a base rate case within 5 years of that request. And that's an implicit consumer protection. It prevents a utility that's already sufficiently funded through rates from overburdening their customers, the ratepayers, with an additional surcharge. There's an explicit consumer protection placed in the statute, and that's that 5% limit on collection. And of course, the statute also provides flexibility in that a utility can come to the commission and seek a waiver of that 5% cap. The statute is silent on the standard that has to be met to be granted a waiver. So I'm going to fall back on a reasonableness standard. And as of today, PPL has not been in for a base rate filing for almost 10 years. It's not coming in until 2026. And there are numerous factors that will allow a utility to stay out from filing a base rate case for that long. Lack of revenue is usually not one of those factors. So I do agree with the ALJ's recommendation to deny the petition. I'm going to repeat again that properly implemented, a DISC reduces the frequency and the cost of base rate cases while maintaining a high level of consumer protections. But it is not reasonable to use the DISC and the waiver process to avoid coming in for the comprehensive review of a base rate filing. The customer protections for using the DISC are enshrined in Chapter 13 of the code, and it is very important that this commission enforce those protections. Thank you.
Thank you for your comments, Vice Chair Barrow. I do have a statement in this matter. I asked my statement be entered into the record, so I read it in its entirety. Before the commission is PPL's petition for a waiver of the distribution system improvement charge cap of 5% of billed revenues. PPL seeks approval to increase its DISC cap from 5% as established in the Public Utility Code to 9% utilizing the waiver provision permitted in the code. The Commission may approve a waiver of the 5% DISC cap in order to ensure and maintain adequate, efficient, safe, reliable, and reasonable service. The Commission has previously deliberated a small set of similar proceedings in the past. Outcomes of these proceedings vary, but as PPL notes, numerous waivers have been approved when the Commission determined that such an increase would help the utilities meaningfully respond to safety and reliability challenges. PPL proposes to utilize increased funds to address recent negative trends in reliability performance. In the Commission's 2022 reliability report, we recognize this, stating, quote, PPL's reliability is beginning to decline, end quote. Additionally, in our 2023 reliability report, we concluded that, quote, since 2015, CMI, or customer minutes interrupted, and the number of customer interruption events are both significantly increasing year over year, and this needs to be addressed by reducing PPL's Customer Average Interruption Duration Index, or CAIDI. In its petition, PPL asserts that if the cap waiver were approved, it can increase and accelerate investments and consistently improve performance, including CAIDI. These investments include targeted vegetation management, non-wires alternatives such as dynamic line ratings, vehicle-mounted camera systems, drones, ground rovers, and predictive failure technologies. The Bureau of Investigation Enforcement, or RI&E, proposes the Commission consider a DISC cap of 7.5% as an alternative. Such an increase would provide PPL with approximately $28 million in additional revenues and increase the average residential customer bill by $1.50. The I&E alternative would be temporary, with waiver expiration achieved at the end of the company's existing long-term infrastructure improvement plan, which is December 31st, 2027, or upon effect of new distribution rates stemming from a base rate case, whichever is sooner. The company's most recent rate case was filed on March 31st, 2015, with new rates becoming effective January 1st, 2016. Exhibiting PPL has not had a rate base filed recently. PPL reached the 5% DISC cap in April of 2021, exhibiting that the company has invested in eligible infrastructure while leveraging the DISC for associated recovery. When considering how long ago PPL last filed a rate case, the fact that the company is presently at the 5% DISC cap, the company's negative reliability trends, the use of the additional funds to address these trends, the modest size of the increase, and the temporary nature of the increase, I find approval of the alternative proposal from I&E to be reasonable and necessary. I place emphasis on the fact that PPL's DISC has been at the 5% rate since 2021. Without any more capacity under its DISC, the company may be disincentivized to advance investments. This temporary relief detailed herein will provide PPL the opportunity to improve its reliability now via additional DISC capacity, while also ensuring our ability to fully review PPL's reliability and finances when any future rate case is filed. It is my hope that this action and the associated rate relief provided will result in PPL's deferring the filing of a future base rate to a date beyond its projected 2026 timeframe. And I just will add to this, this was a hard issue for me. I've gone back and forth with this. Vice Chair Barrow raised some very good points, and as we talked about this before, if this was in 2023, I may have a different opinion. But following 31 rate cases filed last year, and seeing what that did in terms of our ability to process those rate cases, the impact it's had on customers, I'm, kind of picking the lesser of two evils here and voting for this. So I appreciate your comments. Like I said before to you, if this was 2 years ago, I probably would have agreed with you wholeheartedly. But, with the hands we've been dealt over the last 12 to 14 months here, I find it prudent to vote in favor of this. So with that, is there any other comments? Hearing none, is there any objection to taking the previous roll call? Hearing none, the matter passes as amended by a motion by a vote of 3-2, noting the dissents of Vice Chair Barrow and Commissioner Zerfus. Madam Secretary.
Turning to page 4, it is recommended that the Commission adopt the proposed opinion and order in the petition filed by Penn Renewables LLC versus UGI Utilities Electric Division regarding UGI's default service program.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second? Second. Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion?
Chairman, I do have a statement.
Vice Chair Barrow.
Madam Secretary, please enter my statement in the record as though I read it in its entirety, but I will not. Just noting that I will concur in result only. Thank you.
Thank you. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. Matter passes by a vote of 5-0, noting Vice Chair Barrow concurring in result only. Madam Secretary.
Continuing on page 4, it is recommended that the Commission adopt in an omnibus motion the remaining item on page 4, the application of N&W Transportation, LLC, and continuing and ending the omnibus on page 5 with the application filed by Bucksmont Transportation to be doing business as Bucksmont Transportation Services Company and Willow Grove Yellow Cab Company.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. Matter passes by a vote 5-0. Madam Secretary.
Turning to page 6, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion both items on page 6, beginning with the letter of petition filed by the PPL Sustainable Energy Fund of Central Eastern Pennsylvania, and continuing the omnibus to include both items on page 7, both items on page 8, both items on page 9, both items on page 10, both items on page 11, and including and ending the omnibus at the top of page 12, with the cancellation of licenses of certain natural gas suppliers.
Is there a motion to consider the staff recommendations?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Yanora. Any discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it. Matters passed by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 12, it is recommended that the Commission adopt the proposed tentative implementation order regarding Act 129 and Energy Efficiency and Conservation Phase 5.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion? I do have a statement in this matter. Before us for consideration today is a tentative implementation order for Phase 5 of the Energy Efficiency and Conservation Programs established by Act 129 of 2008. When Act 129 was passed into law, the General Assembly was concerned about rising energy costs and looking for ways to lower costs for Pennsylvania ratepayers. The law established targets for the Commonwealth's largest electric distribution companies for both energy efficiency measures that generated permanent, persistent reductions in electric usage, and for programs and measures that would provide temporary demand reductions in the peak hours of electric usage when prices were highest. Since then, the Pennsylvania Public Utility Commission has overseen 4 phases of the E&C programs created by Act 129, each lasting 4 years. During that time, stagnant electric demand coupled with the shale gas boom led to nearly 15 years of relatively low and stable prices. Over those years since their inception, the E&C programs run by our utilities have delivered approximately $4.5 billion in net savings to Pennsylvania's electric customers. Now, as we prepare for Phase 5 of the program, the cost of electricity and the question of guaranteeing adequate electric supply for the system are once again looming large in Pennsylvania, just as they did back in 2008. In this environment, I believe Act 129 is one of the most important tools available to the PAPUC to meet our mission of providing reasonable, adequate, and affordable service to the Commonwealth's electric ratepayers. With that in mind, I would ask all parties to utilize the comment and reply comment periods on the tentative implementation order to carefully consider and suggest ways that we can maximize the impact of the budgets that will be allocated in the coming phase on affordability and resource adequacy. And I am eager to hear all suggestions to enhance our E&C programs and consider them as we move forward towards a final implementation order over the next few months. Especially in a time of rising costs, these ratepayer dollars are a precious resource, and we owe it to our ratepayers to use them as prudently as possible in ways that can provide savings to customers and preserve the reliability of our overall power grid. Any further comments?
Mr. Chairman? I'll associate
Barrow.
myself with your statement.
Thank you, Vice Chair Barrow. Any further comments? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it, matter passed by a vote of 5-0. Madam Secretary.
Turning to page 13, it is recommended that the Commission adopt the proposed order regarding the registration of securities certificate filed by the Columbia Water Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yenora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it, matter passed by a vote of 5-0. Madam Secretary.
Turning to page 14 and matters presented by Chief Counsel Screven and the Law Bureau, it is recommended that the Commission adopt in an omnibus motion both items on page 14, beginning with the joint application of Deer Haven LLC and PL Utilities LLC, and ending the omnibus with the ratification of the application of Commonwealth Transport LLC for emergency temporary authority.
Is there a motion to consider the staff recommendations?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Mr. Chairman,
Vice Chair Barrow.
I'll be a no on the second item, Commonwealth.
Okay. All those in favor, please say aye.
Aye.
Those opposed, no.
No.
The ayes have it, and the first matter passes by a vote of 5-0. The second matter passes by a vote of 4-1, noting the dissent of Vice Chair Barrow. Madam Secretary.
Turning to page 15, and matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt the recommended decision of A.L.J. Vero regarding the rate case proposal of the Newtown Artesian Water Company and joint petition for settlement.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Yenora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, matter passed by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 15, it should be noted that the formal complaint of Jeffrey Berger versus Frontier Communications has been postponed to the public meeting of March 13, 2025. Mr. Chairman, that concludes the regular agenda. Turning now to the carry-in. On page 1 of the carry-in agenda, it is recommended by the Office of Special Assistants that the Commission adopt the proposed opinion and order regarding the petition for partial reconsideration and/or clarification filed by Aqua Pennsylvania Water and Aqua Pennsylvania Wastewater.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it. Matters passed by a vote of 5-0. Madam Secretary.
Turning to page 2 of the carry-in, it is recommended by the Bureau of Technical Utility Services that the Commission adopt the proposed order regarding the joint application and joint motion filed by Deer Haven LLC and PL Utilities LLC, and it pending Section 529 proceeding.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a motion on the matter.
Commissioner Nora.
I ask that my motion be entered into the record as if I read it in its entirety. Before the Commission is the joint application of Deer Haven and PL Utilities. This application seeks Commission approval of the transfer of wastewater assets from Deer Haven to PL Utilities. The application also seeks an associated Deer Haven abandonment and PL Utilities authorization to provide wastewater service. Under the circumstances presented, I believe PL Utilities possess the technical, legal, and financial fitness to acquire Deer Haven wastewater system. I also believe that granting the joint application is necessary to provide PL Utilities, which is a nearby wastewater provider, with the opportunity to resolve the long-standing service difficulties faced by Deer Haven. Right now, Aqua Waste Management is managing the Deer Haven system as a receiver. Aqua ratepayers are experiencing the significant wastewater pumping, hauling, and treatment costs, as Aqua must treat Deer Haven effluent off-site. I believe that the public interest requires the Commission to grant the application with self-executing timeline to minimize these costs. While the ratepayers' costs are significant concern, I do not overlook the DEP approvals utilities must obtain before it is able to provide the treatment services needed by Deer Haven customers. The Commission's approval of the joint application should be conditioned upon PL Utilities' compliance with the DEP requirements. PL Utilities is required to apply Commission approval of its proposed transfer to a jurisdictional utilities assets of PL Utilities to the appropriate filings of the Commission. Therefore, 1, the application of Deer Haven LLC and PL Utilities LLC is hereby granted, subject to this condition set forth in this motion. 2, if the condition referenced in the ordering paragraph 1 are not satisfied by August 31st, 2025, the joint application shall be automatically consolidated with the pending Section 529 proceeding concerning Deer Haven. And 3, that the Technical Bureau Utility Services draft opinion and order consistent with this motion. Thank you.
Thank you, Commissioner Unora. We've heard the motion by Commissioner Unora. Is there a second?
Second.
Seconded by Vice Chair Barrow. Any discussion?
Mr. Chairman,
Commissioner Zerfus.
based on the record in this proceeding, I'm going to be a no on the motion. I would prefer to make a final decision on the acquisition of Deer Haven's wastewater system based on a fully developed record in this Section 529 proceeding that's pending before the Commission. Thank you.
Thank you, Commissioner Zerfus. Any further comments? I do have a few comments in this. This case is tough. I mean, this case puts the Commission between a rock and a hard place. Having said that, I do believe it is in the vested interest, given the investment that Deer Haven or that Pocono Lakefront has made in the new treatment system or new treatment plant, to give them and it shows their investment into the region to give them an opportunity to run this system. So I will be voting in favor of the motion. Any further comments? Hearing none. All those in favor, please say aye. Aye. Those opposed, no.
No.
The ayes have it, and the motion passes by a vote of 4-1, noting the dissent of Commissioner Zerfus. On the matter as amended by the motion, take a roll call or take a same. On the matter as amended by the motion, is there any objection to taking a previous roll call? Hearing none. Matter passes as amended by the motion by a vote of 4-1, noting the dissent of Commissioner Zerfus. Madam Secretary.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
There's no other business to come before us. Is there any objection to adjourning? Hearing none, we are adjourned.